Good morning.
Did I pronounce your name correctly?
Nobody does.
Well, how would you like it pronounced?
It is pronounced Linda Frideres.
Frideres.
Yeah.
Thank you. Sorry. All right, Ms. Frideres, can you raise your right hand? Do you swear or affirm that the testimony you are about to provide is true and accurate?
Yes, I do.
Thank you. Please state and spell your name and provide your address for the record.
It is Linda Frideres. It's Linda. It's Frideres. We live at 106 Spring Valley Drive at Livermore, Iowa, 50558.
And is this the appropriate parcel displayed on the board right now?
Yes.
Okay, thank you. And that is in Kossuth County, is that correct?
Correct.
All right, thank you. Can you describe the current use of the property and any future plans you may have?
I have got notes. I hope it's okay if I just kind of read them or use them a lot. It keeps me on track.
Absolutely.
Okay. We purchased that St. Benedict 80 tract in 1997, and we rotated planting corn and soybeans each year. We retired 3 years ago, and our tenant does the same. All our farmland will be given to our daughters, and their tenant most likely will do the same thing, as that's what the land is suited for.
Can you make sure you speak into your mic, please?
I sure can.
Feel free to move anything around that you'd like.
Is this better?
Yeah.
Okay. The general description, there's no buildings, there's no other structures. There is a drainage tile, so the excess water does drain off well. When we purchased the land, there were no tile maps. A farmer whose land borders ours, both to the north and the east, had a map drawn by his deceased father showing different tiles. If you look at map number 1, or the first exhibit.
Hold up. Let's make sure we can get everything pulled up.
That is the correct one. The Sun stated that there is a 4-inch tile that runs along the west side of their land, which would...
Hold on, Ms. Frideres. We're going to make sure that parties get a copy first so they can see it as well. Thank you.
He stated there's a 4-inch tile that runs along that west side
Ms.
of their
Frideres,
land.
we're just going to let the parties... You're all right. You're doing fine. Okay. Go ahead.
Okay. On the west side of the land, there is a 4-inch tile that runs along the west side of their land, and it shows that it extends down past our border, but we have no way of knowing how far that extends into our land, actually. Depending on how far south it does go, it could be in the construction zone. if that is where the construction zone will be, is in that lower left corner. There's another tile. It says 147 steps to the east, and that also goes down to our land. And the same circumstance, we're not sure how far that extends in. The people that we bought the farm from did not have any tile maps either, and I went back through the abstract and I couldn't find anything on it. If you go over to the other tiles to the right, there are certain ones that look like they go down into our land as well, where the arrows are at. Same thing, we simply don't know how far they go down in there.
Can we pull up well, maybe we don't need to. So just to clarify, when looking at page 1 here, the top of the page is north, the right of the page is east?
Correct.
Okay. And all of the tiles represented on your exhibit, are they on your property?
Nope, they are. That's on the farm to the north. The
This
one
is
above our.
okay. So
Everything on this map is on top of the red area.
okay. Can you scroll up a little bit, please? What is that gravel road there at the bottom? Can we pull that up?
That gravel road, I believe, is 180th Street.
Okay. On your exhibit there, everything is pointing, the red arrows, I believe they're red, at the very bottom of the page. What does that say?
That is not this exhibit, this one, the map, that is not our land.
That's
it's
all
land
north.
up north.
Okay.
Yeah.
So nothing on this is in the red shaded area. Just wanted to double check it, but it feeds in.
That's correct.
Okay.
But that's the best that we have on tiles on that end.
Do any of the tiles extend into your property?
It shows that some of them do, but we don't know how far.
Okay. And they
That we could actually say that yes, they do. There's some reason to believe that they do, that I can show you on another map, but like I say, we can't. We don't know.
Okay. And they would, if they do, or they do, but they do extend from the north, south into your property. You just don't know how far, which direction once they cross that line.
Correct.
Okay. Thank you. Go ahead. We'll just walk through your exhibits and let you explain.
Okay. If you go to map number 2, the county provided this. This is the drainage district. And if you look in the lower right-hand corner, there is a county drain tile that starts on our property. If the bottom line, the top line where it says L2, looks like it extends into our property. There are some tile down there that we think connect into that county tile. So there's a 12-inch county tile on our land that goes into the field to the east that drains into a Kossuth County 16-inch clay tile that goes into the field south down under the road. So the pipeline is going to also have to go under that county tile and go west. And if that was broken, that would affect our land and the neighbor's land quite a bit. Do you have any questions on this particular map? Okay. If we look at the map, the third map, this map conflicts a little bit with the county map, but it does show a county tile here. it shows some private tile down in that right-hand corner. And then if you go into the neighboring land to the east, shows a tile that's coming down. And our neighbors that, or the guy who's the son, that is that tile running from north to south on their land. Yep, that one. That connects to that county tile. But this is the tile where all the water drains from the 22 homes up in St. Benedict, which is just north of that top field. St. Benedict is I would call it a village or a hamlet. It's got 39 people living there, about 22 homes. But their water all drains down into that tile right through there. So that drains that's a private tile. That drains into the county tile. If the county tile is broken, and that our tile also connects into that tile, and all this water from St. Benedict is running down in there from those homes, I'm not exactly sure what would happen then, but I don't think it would be good. Okay. If you look at number 4, map number 4, that does show there is a natural gas pipeline that runs through our land. It comes from the east, goes through the west. There was an easement created in 1954 with Northern Natural Gas Company to bring that product to the people in the area. In 1991, it was changed to Enron. It goes from the east, runs diagonally to the west across our land.
I'm sorry, did you say who was the owner?
Enron now is in 1991. They have the easement.
And on Exhibit 4 there, that roughly square would represent the parcel that we're speaking about today.
Yes, that's the 80 acres of our ground.
Thank you.
It's not probably drawn to scale.
You're fine. You're fine. Thank you.
This map I just thought showed better the proposed route and the easement area, and I probably might talk about that later, but I thought it did show it better. And again, we don't know whether there's tile under there or not, but that also depends on if they decide to leave it there. I don't know that as well, since none of these, and the easement, even the easement agreement states that this is not, or can be changed. It may not be specific. That one, some of these exhibits probably we don't need to use even. They're in there. If I want them to come up, then I can let you know. So if we can just take that one out of there.
Okay.
And just stop it, would go back to the map that you were on. There you go.
So for these exhibits, you just want to be able to refer back to them. Okay. So
why not? I'll tell you if in my notes I've kind of got it all lined up for what exhibits we need when I'm speaking about them. If that's all right.
So you move to submit these to the record. Yeah.
Yes.
Okay. Thank you. Are there any objections?
Just to be clear, all we're moving right now are the pages up to this map.
Those all should be, yes,
Pages 1 through
1 through 5.
1 through 5.
Go through that, yeah, and we have no objection to those.
Okay. Let's admit pages 1 through 5 as Frideres hearing exhibit 1. Pages 6 through 12. Ms. Frideres, we're still going to talk through that.
Maybe.
Okay. Thank you. Hold on real quick.
Okay.
So we will admit those into the record. Okay. Go ahead.
As to the land itself, again, the field is, it drains well. There's a good drainage outlet less than a mile away. The land in our area is averaging, when sold, $15,000 to $16,000 per acre, sometimes more than that. The corn suitability rating on it is 79. We have a 10-year proven average yield of 65 bushels for soybeans, 215 bushels for corn. There are 2 access points to that field. There was one in the southeast corner and one in the northwest corner.
So say those entrances again, southeast and northwest.
Correct.
Okay. Thank you.
I know, I'm just kind of remembering other questions that have been asked of other witnesses, and I know our tenant that farms it now, he does have crop insurance. There's no streams, no bodies of water, no above ground facilities. There's no timber, no forest. There's no wetlands or other programs.
You just went through my questions faster than I could check them off, so we might get redundant here.
Sorry.
Thank you for the detail on the drainage tile and the gas line. Just to clarify, is there any other underground infrastructure?
Not that we're aware of.
Okay. And any other easements held by third parties?
Not that I'm aware of.
Okay. Any other features or conditions that might not be readily available based on the map or the exhibits?
I don't think so. It's a pretty straightforward piece of ground. We don't have much problem with water. It seems to drain off well.
Can you describe any specific concerns you have and any recommendation you have for board action to address those concerns?
Yes, I do. Our feeling is that we don't think this pipeline company or any other pipeline company should be granted eminent domain. We're not sure how this fits into the general public's interest. I looked at the board's mission and vision statements, and a for-profit company is literally going to take land for their use forever without ever paying for it. And it is going to destroy very rich soil that Iowa is really lucky to have. They're going to get a lot of tax credit money, and they're going to put a very volatile substance in a pipeline that goes to North Dakota. We don't think private land should be sacrificed for a for-profit business unless they're voluntarily given easements. I know ethanol plants are needed like a lot of other businesses in Iowa, but where do you draw the line as to which business deserves eminent domain the most? One of our thoughts also are that this seems to be such a rushed process, and I've been trying to educate myself somewhat on a few things, but I know that about 5 of the state's ethanol plants do uh, carbon capture some of their own dioxide to some degree. They sequester it themselves. And I've never heard of this before, but the Iowa Geological Survey stated that half of the biofuels facilities located in Iowa are in places that have the potential for on-site carbon sequestration, and that it's also possible that huge quantities of carbon dioxide could be stored in the mid-continent rift system, which lies beneath nearly half of Iowa. So I tend to wonder why that maybe has not been explored before resorting to eminent domain, and maybe it has, but I've not heard of anything about that. I think one of our biggest concerns is the magnitude of this pipeline. Summit's pipeline, if I'm correct, is about 2,000 miles total, and they need approximately 1,200 parcels through Iowa, and about 2,900 parcels are needed in total. In February of 23, Summit Carbon Solutions website stated that they had 4,000 signed easement agreements, or 1,250 total miles of right-of-way secured. So they have 750 more miles of needed easements. The biggest concern is that the size of these parcels, like in our land, it shows a very, very small area. But the easement wants to take control of the entire 80 acres. So it's not just where the pipeline goes through, it's the control they have over the entire affected parcels. With 4,000 easements and 754 miles to go, how many easements will they actually have under their control? It's kind of frightening to do the math and think about how much land Summit will actually have control over. And they also have the right to sell this to whoever they want to. So we don't know where that land will end up all the way through the pipeline. There's Wolf's 300 mile and Navigator has 1,300 mile line needs. They will be standing in line for eminent domain for sure if this is granted to Summit. So there's going to be a lot of farmland that's no longer under landowner control due to the easement agreement. That kind of leads me to another, I think at this point, when we're defending our rights, Summit should be able to give us an established route rather than proposed routes. Their agreement says they can change anything, anytime. It doesn't matter if the easement is signed or not. And they want full control over that entire property. I don't understand that. I will say I do appreciate being able to file objections and to testify today. I know it's repetitive themes from all the witnesses, but I think it's important for everybody to hear those repetitive things over and over. Seizing land, private land, I think is a big deal. Seizing land by a for-profit company, I think is a really, really big deal. So why do they need control of the entire parcel? Why do they need to control all those thousands and thousands of acres in perpetuity? To me, it seems like they have long-term plans. If they need a forever easement, they can do anything with it for as long as they want. It makes me worry about, depending on what they do, how much use of our land will we have? It makes me think of the first day, I think it was Nelva Quinty, I think her name was, but she testified that, and who would ever think, she has a natural gas pipeline going through their land. Dakota Access is going through her land, and her map showed Summit wants to go in there as well. I never dreamed that much land could be disrupted by, especially by eminent domain. You know, our land is our income for the rest of our lives. We just retired 3 years ago. We will never have the peace of mind knowing what income we'll have from that ground. For 44 years, it's what we worked very hard for, was to provide for our own retirement. We worry about how much it will devalue, if we would want to sell it, or if we can even sell it with all those liens. It just, so much depends on how much Summit takes of it over perpetuity, forever. Their easement terms, they can use our land and as much of it as they desire. If approved by the IUB, the Summit will be able to forever route and site its pipeline on, under, through, over, and across any of our land. They can conduct any pre-construction, construction, post-construction activities they deem necessary at any time, forever. And this is land that is trying to be farmed, which has very set windows of time for everything. We will be restricted on what we can do with it, how much we can use, when and where we can travel on it. And that will extend down to not only us, and we're not actively farming, but our tenants, our daughters that will inherit this land will use tenants. So future generations for forever will be told how they can use this land. And what will be left of these 80 acres to generate income for us in our retirement, we won't know. In the first paragraph in the easement, it states, Summit has 24 purposes. They owning, accessing, surveying, establishing, layering, constructing, reconstructing, installing, realigning, modifying, replacing, improving, substituting, operating, inspecting, maintaining, repairing, patrolling, and protecting, changing slopes of cuts and fills to ensure proper lateral and subadjacent support for and drainage for, changing the size of, relocating, and changing the route or routes, plural, of this land, abandoning in place and removing at will, in whole or in part, pipeline not to exceed 24 inches in nominal diameter. And this is forever. And it makes me wonder, what on earth are they planning to do? That they have that many options of what they can do. And all that is without any permission from the owner, with no input. It just seems very unfair, very unjust to sign anything that vague. And this is our land, but it feels like it will be their land. Another big concern that is, even if there was a precise route, and once construction starts, and Summit varies from that route, from the size or the depth or the widths of the easement roads or the use of the easement roads, if they replace soil incorrectly or build something else or something breaks or damages a tile, I think that's going to be a huge problem for us. And getting the construction halted and then stopped seems almost impossible. The damage is going to be done. If they do something outside the easement area, who's going to make them change or fix that? How long will it take them? If a tile was broken, how long will it take before a landowner notifies them? They have to investigate it. They have to confirm the claim and determine if that claim is valid, and then repair or replace it. How quickly will that happen after the landowner notifies them? Farmers have really short windows to be in that field to do what they need to do to make their income. They need to, in the spring, they need to work the ground. They have to plant, they have to spray, they have to fertilize. Harvest, there's combining, there's fall tillage. If they don't get any of that done, there's going to be a huge amount of damage done to farmers and landowners regarding costs and income, because Summit controls when we can be on that land. Summit's access agreements is a free and unobstructed easement into, through, on, over, under, and across our land forever for the purposes of ingress and egress to the pipeline easement. We must keep it free and unobstructed. We cannot have crops, equipment, livestock, or anything that stops Summit's unrestricted total access to our land. And they can travel anywhere on that land and not just the easement area. To have access to a landowner's entire property, especially forever, seems unacceptable. Summit claims in their materials the landowner can use the land as they did before, but we don't even know if that land will be usable for farming or if they're already using it. The temporary easement has to be at all times convenient for Summit, and that is stated in the easement. I have heard witnesses ask if they would like to be consulted on decisions, different decisions that Summit is making. And I've heard witnesses asked if they realize how many rights are being taken away. Landowners won't have a right. Summit could consult with them, but Summit's decision is final. So we would like to ask the IUB to really take a look at that easement and really think about what this actually means for landowners, especially farmers. Summit also demands a temporary easement, but there's no definition of temporary. How long is that? Summit reserves the sole right to also locate upon our land and use temporary construction areas and additional temporary workspace areas. There is no limitation on how large those can be, and that can take away farming acres. How long is temporary, and how long is it going to stop us from using our land, because we cannot be on the land if Summit is using it or is constructing on it. The temporary easement that's used is it going to be used as a road for them to move all their equipment across? if they use it, depending on how long temporary is, that little land could be ruined. It might not even be able to restore ever again. And if you start to compute that into dollars, with our land at, say, just in the middle, $15,500 an acre, even if they only use 6 acres, that alone would be $93,000 worth of land. And that includes nothing about the loss of crop soil or the loss of crops and soil damage. They want to pay that for 3 years of compensation, but not for the rest of the time. And there will be problems with that. But then what if Summit decides it needs 12 acres or 20 acres? Because they can change the route or routes, which I don't understand the plural of that, but that's what is there. It would be nice if maybe there was the option they could just purchase the land that they want to use, and they use exactly what they purchased, like everybody else, and then they could pay taxes on it, or they could pay annual rent, just like anyone else that uses somebody else's land. We would have the option then to sell or not sell, or rent or not rent, but at least we would know what our income would be, or our tenant would have that same knowledge. Our tenant is not happy about having a pipeline there. And again, he doesn't know. He's already prepaid for fertilizer costs. They've prepaid seed, they've prepaid everything. And if they can't get in there to do what they need to do, they're going to lose money. It's obvious. That leads more into the easement, where Summit has the sole and exclusive right to sell, assign, apportion, mortgage, or lease this agreement, or transfer this agreement in whole or in part. So it would be approved that any future unknown person, entity, company would be in control of our land forever. And all the land that's being in this pipeline forever. It's not just these little parcels. It's entire fields, thousands of acres. We have to deal with agents, employees, and designees, as they can also use the easement Summit has described. Specifically, they state that we as the landowner grants, sells, and conveys unto the company, Summit, and all future unknown successors and assignees for use by the company and its agents, employees, designees, contractors, guests, invitees, and successors, and assignees, and all those acting by or on behalf of it. Forever. All those people. We think it's highly unlikely that this easement will be sold, but we are very concerned about unknown investors having authority on what they might do. If Summit sells or assigns any part of the agreement or the easements to anyone else, then Summit, in the easement, shall be released of its obligations under this agreement. We believe that any new entity or others that would seek to become owner and operator of this pipeline should have to first apply for and be granted permission to take on this project over from Summit, and they would have to assume the obligations. And it would be great to take away that forever thing. An unknown person or a company or a government could have terrible impacts on Iowa with the amount of land, not just the parcels, that Summit would have control over, or who they would sell it to. Is there any way for the state to not grant permission to somebody? I don't know. Nobody would know who all this land would forever be contracted to. Summit also asks for the transportation of carbon dioxide, which is what we understand they're doing now. I don't understand. It's naturally occurring constituents and associated substances and any pertinent facilities above or below ground, including aerial markers, power drops, telecommunications, cathodic protection, and other such equipment is as used or useful for the foregoing purposes. To me, that sounds like they can place any facility and equipment above the ground or below the ground on our land that Summit deems is as used or useful for the foregoing purposes. But there's no time limits, there's no restrictions, there's no notice requirements. We think there at least has to be a limit to what can be transported in this pipeline, not knowing what could possibly be flowing on or under or through or across our land creates possible serious injury to anybody that works and lives there. As I said before, St. Benedict, just a mile north of our land, has 39 people living there. Summit also wants the right to abandon in place their hazardous pipeline on our land. And I don't think that should be allowed. Summit should remove the pipeline at their own expense, at the landowner's request. Getting them to actually do that, I think, would be a problem to get them to remove it. We would have to hire lawyers, and I think there would be a very expensive, drawn-out, expensive legal battle. There's no provision for landowner compensation for such abandonment, and there's no right for a landowner to demand removal. Many witnesses have talked about the liability insurance aspects of this. Summit can allege that either we or any person who is on our property is negligent, so we could be exposed to damages that could easily bankrupt us. I think it would be an expensive battle, even over the question of whether damage was an act of negligence or something else. I think Summit and all their future unknown successors and assignees and its agents, employees, designees, contractors, guests, so forth and so on, need to be responsible for those injuries or damages of any kind, either directly or indirectly caused by the release of that carbon dioxide from their pipeline, unless it was intentionally committed by a criminal act by the landowner's part. We don't plan to do that. It feels like an increasingly unfair, unbalanced fight. Certainly ourselves as landowners, we do not have a legion of lawyers or the funds required to deal with being buried in legal disputes or anything else. Summit's easement is absolutely critical in these proceedings. Nobody can change the terms of those easements that we would be forced to sign. The negative impacts on us, on our land, our tenants, are forever. I know there's been so many other objections filed by others that have way more specific knowledge than I do on other ways of carbon capture, the dangers of the pipelines, the very definition of what's in that pipeline. Is it liquid? Is it supercritical? There's just so many of those that are concerning everybody, and even non-landowners are concerned. Our understanding is the Pipeline and Hazardous Materials Safety Administration is still revising its rules concerning carbon capture. That concerns us that this hearing is going on before Summit even knows what the rules will be. We have soil concerns. I had done some reading on soil damage when we dealt with the Rock Island Clean Line electric transmission venture that wanted eminent domain, but they did not receive it. I read some Natural Resources Conservation Services articles on how pipeline construction can impact farmland so greatly. I don't know whether you want me to go into some of the things that they listed. That's all right, I will. Okay. The article I read, and this is just some of what I picked out, the adverse impacts on farmland through pipeline construction is the mixing and compaction of topsoil and subsoil, long-term changes in field drainage, soil erosion, interference with surface and subsurface draining, flooding of fields from excess trench water, spread of diseases from parcel to parcel without proper protocols observed, migration of weeds, rise of excess rocks to the surface, rutting the soil, especially when wet, and that wet conditions defined by Summit or defined by a landowner can be different. They stated that just 1 inch of summer rainfall over 5 to 10 days can cause ruts exceeding 7 inches in depth under normal construction equipment. Temporary access roads needed during the construction to allow ingress and egress. One pass of heavy equipment on the soil surface can create 70 to 90% of compaction impacts. Axle loads of 10 tons may cause compaction to a depth of 30 inches. Their list goes on and on. I am just taking it on their word, the Natural Resources Conservation Services, that what they're saying is true. I have no way to dispute that, but it sounds terrible, all of it. I read a lot of objections filed in the docket. They cover so many different concerns on carbon capture, carbon emissions. We also attended the first informational meeting that Summit held in our area, and that kind of started everything off badly. It was held during bean harvest, which is can be a very limited window of time for farmers. It's also a very stressful time. It wasn't held in Algona, which is only 3 miles north of the proposed pipeline. It was in Lakota, nearly 30 miles further north. We drove 40 minutes to get there. Many farmers stopped bean harvest to go there, and they asked Summit why the meeting was held there. Their response was the internet was better there. We were in an old school that had been closed for about 20 years, and the internet did not work when we tried to talk to the land agents afterwards, and they needed to use it. Algona, the county seat, 3 miles from this proposed pipeline, had plenty of event spaces that were available. Nearly everyone could have driven there in 15 minutes or less. Needless to say, no one at that meeting was very happy. We also attended a rally at the state capitol. There's just so many issues to consider, so the push to get eminent domain status seems very rushed. We have a lot of safety concerns, especially where our land lies. The dangers of carbon are very real in this pipeline. In our rural area, nearly all of the emergency services are volunteer, both EMS and fire department. They have very limited crews and small budgets. The closest fire department that would be to our land is in Wesley, which is 8.5 miles away with 21 volunteers. Not all of them have completed Firefighter 1 training. Not all are equipped with the scuba gear that they need. Their response time during weekday working hours can easily be 7 to 10 minutes before they're out of the station. With a drive, it could be nearly 20 minutes before they would arrive to our land. Corwith's all-volunteer department is 9.5 miles away with about 12 volunteers. The largest town, Algona, is 11 miles away from our land with 20 volunteers. Summit claims it will train fire departments and equip them with what they need, but when? Who's going to make sure that every small fire department in Iowa along this pipeline route has been trained and equipped, and that it's done before the pipeline is used? St. Benedict, just 1 mile north, has 39 residents that would be in danger, as would any emergency personnel. We have friends in St. Benedict. We know many of the firemen. It makes me think of the woman in Mississippi when they had the pipeline rupture there. Is it Satoria? I'm not sure how I'm pronouncing that. A woman was there. Her 2 sons and neighbor called to say they were coming to get her because there had been a rupture. They never made it there. They were found unconscious in their stalled car. They did live, but they all are suffering lingering, debilitating health problems. I don't want that to happen to anybody living in our area or the rescuers. I know that Mississippi leak was called a human error by a pipeline operator, but Summit or any other company is going to have to hire humans to build and run this pipeline. Hopefully they're very competent and very smart and good at their jobs, but at the end of the day, they're still human. Iowa winters can freeze valves. Ruptures or breaks can and do happen. Shutoffs can be 20 miles apart according to some of the literature. I am curious about their warning system. If there is a rupture or a leak, how is that controlled? Is it by cell phone? Is it by internet? There are areas around, especially around St. Benedict and other areas of Iowa, where cell phone and internet services can really be unreliable due to perhaps weather or the lay of the land. Then how would that pipeline be shut off? Kossuth County is a large county, estimated about 41 miles across. Would there be an immediate response sent to Kossuth Dispatch Center? Or will someone from Summit have to drive to the suspected problem, determine what's happened? And if so, there could be a lot of people that would be dead by then. If you move into compensation, our concerns that Summit wants to provide a one-time payment. They seek to cap damages to growing crops and yield loss for only 3 years. And they will pay landowners a reasonable sum, depending on who they think is a reasonable sum. There's no method offered as to how that would work. 3 years will not cover damage that will be done. We were offered 4 payments, and those include 3 years of crop damage and easement compensation. The land per tillable acre they are using is $10,934 for permanent easement acres. where farmland in our area has been selling for 15,000 to over 16,000 per acre. Their first offer to us was a total of $2,832 for everything. The second offer was $3,783. The third offer was $24,772. The last offer was $16,000. It had dropped $16,682. None of those offers comes nowhere to compensate for what we're going to lose in peace of mind, in control of our land, whether we'll be able to rent the land, our income from it, the loss of crops. We spoke with our tenants. He does not want that pipeline, but he also would expect to receive crop damage compensation from us. That pretty much covers most of our concerns, which takes us to my next thing that I have is you asked if we had recommended an alternative route. Question number 4. And I am almost done. Okay. If you look at exhibit number 12, the very last one, it's probably going to be easier to understand what I'm talking about. And it's a map from a plat book showing all the owners of the land. Yep. Summit is going to go south of that road on the south end of our farm, and it's going to be going west. Summit could keep going west past the intersection, go under the road, and then turn north and completely miss our land. But it seems kind of awful to wish this upon someone else that doesn't want eminent domain either. Better yet, they could just continue straight west through areas that are completely, simply grass, owned by Kossuth County and the USA. If they did that, they would hook up with the parcels on the other side of that's not shown on this page that are further west.
Ms. Frideres, did you want to move to submit this as evidence?
Yes, please.
Okay. Are there any objections? The plat map number 12 at the top will be admitted as Frideres hearing exhibit number 2. Thank you, Ms. Frideres. Do you have anything else to add?
Yes, I do.
Okay.
Not much.
You're fine.
Question 5 said to please elaborate on any concerns regarding the project. And this is just kind of a recap over some things. Summit will have immense power over an immense area of Iowa. And so will whoever this gets sold to in the future. They can change. It feels like they can change and take everything and anything they want in perpetuity, no less. Forcing us and all the landowners to give our land to Summit is just unfathomable. We hope the IUB takes a step back, looks at what is happening to Iowa land and how much Iowa land. There are landowners that don't want to participate in this pipeline. We feel an exceedingly dangerous precedent is being set that for-profit companies can seize any amount of land for their own profit, not just the land that their parcels go through, but the entire area. Denying Summit's petition entirely is what we would hope would happen Eminent domain is going to change our land, its value, and our lives forever. The easement language and powers are far too vague. They're biased towards Summit Carbon or whoever is going to hold them, and they cover too many areas. Navigator and Wolf will add to the amount of property being controlled by for-profit companies. Anything we want to do with our land will be subject to Summit's permission. We don't know how much land they will take, where the pipeline will actually be, the length, or anything. They can change everything and anything at any time. The economic impacts now and in the future will be enormous. Our mental health is going to be challenged as well. It's well known that farmers are connected deeply to their land. We will have no leverage against the terms in that easement. We will not be compensated what we think is a fair price, but what Summit deems is fair. We deserve better treatment than Summit Carbon taking our land. We deserve our full retirement rights and peace of mind. If the IUB grants Summit eminent domain, then we ask the board to at least put very severe limits on Summit's power to take all the land for their own use, any amount at any future time at our expense. Every year they should pay for crop damage as well as rent for exact acres used, along with penalties if they use more land than the easement states. There's one thing that is crystal clear, is that, and I don't envy you, is your responsibility and ability in this issue to eliminate eminent domain in this case. The responsibility would then be placed back on Summit, exactly where it should be, to do what it takes to get only voluntary easements, or get them perhaps through better payments and more reasonable easement terms. The last thing I'm going to say, this makes me think, I don't know when I thought of this, this makes me think of the old story of David and Goliath. I feel like I'm David and my husband, and we have this really poor weapon of a slingshot, and we have one rock to use, and that rock is you. It's the IUB board. The IUB board has control over what's going to happen.
Thank you. Are there questions from the parties? Is Wally online? Okay. Farm Bureau?
Hi, Ms. Frideres. My name is David Myers, and I am an attorney with the Iowa Farm Bureau Federation. You covered a lot of ground through your testimony, which is great, so I just have a few follow-up and clarifying questions for you. Do you have one farm tenant or multiple?
One. Well, on this tract of land?
Correct.
One.
And did you provide the name of your farm tenant to Summit during this process?
I honestly can't answer that. I don't know. A land agent came to us several different times. The first occasion, my husband and I listened, but my husband stood outside the door and talked to him. I don't recall the tenant's name ever coming up in any conversations that it. So I would say no.
Okay. And you mentioned the farm tenant has crop insurance. Is the farm tenant enrolled in any other federal farm programs?
I don't think so.
And then you, as the owner of the parcel, are you enrolled in any federal farm programs?
No.
Do you know the size of the pipe Summit would like to install on your parcel?
I know it says, the easement says up to 24 inches.
So you don't know the specific size they plan at this stage?
Up to 24 inches. I don't know. That's all I know for sure.
if the pipeline was granted, with that understanding, would you want the board to rule in its order that someone has to identify the specific pipeline size to be placed on your parcel?
I think Summit should know the exact size, the exact place they're going to, I think they should have everything should be, for us to sign an easement, they need to provide exact terms of what they're going to do and what that project encompasses. If that makes sense.
Understood. Thank you. Those are all the questions I have.
Thank you. Ms. Colas?
Hello, Mrs. Frieder. You gave excellent, very informative testimony, and I want to thank you for that. I think you brought a lot of things to the surface that have not really been around. Now, the Farm Bureau attorney asked if Summit asked to have the tenant's name for your land. To talk to him, the Summit rep asked for the tenant's name.
I'm not sure I understand the question.
Did you give the farm tenant's name to Summit? Did they request it?
I myself did not. I don't think my husband did, but I don't know that.
Was there any conversation with the Summit representative that said only the landowner had a right to discuss the pipeline with him? Only the owners, not the tenants.
I don't think there was any conversation that had the word tenant in it that I'm aware of.
Okay, and then you also mentioned that they could put up to 24 inches into in the size of the pipeline. Is that correct?
Yes.
They didn't give you any other dimensions, smaller or anything, just up to 24 inches.
I'm going by what the easement agreement says. Because that is what we would be signing.
Do you feel as if Summit has coerced you into signing this easement agreement?
I guess they've been persistent. But eminent domain will be coercion. If we don't sign this easement agreement, that is obvious we don't want to sign for many reasons, then the threat of eminent domain is hanging over our heads.
The reason I asked that is because you indicated that you had 4 different offers with Summit.
Yes.
2832, 3783, 24772, and then 16682. I'm questioning why they would decrease an earlier offer.
Okay, now I think I understand. We thought that was interesting too, that rather than the offer going up to perhaps make us more interested in signing the easement, it went down by quite a bit. To me, that felt like this offer is going to start going down more and more and more. And so it feels like you should have signed at 24,000.
Thank you. No further questions.
Thank you. Mr. Dvorsky?
Thank you, Mr. Ms. Frieders. Is that correct,
Yeah.
Frieders?
Mhm.
I just want to clarify some things that I'm concerned that some of the things you're concerned about may be based on information that isn't entirely accurate. Are you aware that the board, if it approves this project, will approve a specific route that will be attached to the permit as a legal description?
Can you repeat that again?
Sure. Are you aware that if the board approves this project, it will approve a specific route that will be attached to the permit as a legal description?
The board will approve a specific route.
Correct.
Is this a specific route that can be adhered, that will have to be adhered to?
I guess what I'm at.
Yeah,
Unfortunately, I'm not allowed to answer your questions, but I guess what I'm asking is, are you aware that the board will approve a specific route? And if you're not, that's fine. I'm just asking about your awareness.
I don't feel like I can answer that because I don't feel like I'm really understanding what you're saying.
Okay.
So Ms. Frieders,
Yeah.
you're not compelled to answer any questions, but you can ask him to restate it.
Okay.
But he can't answer
Is there a
questions.
way you can state that so maybe I can't figure out what you're trying to ask me?
And I'm really just asking about your awareness. So at the end of this process, are you aware that the board will approve a specific legally defined route in which the pipeline has to be constructed?
I am under the understanding that the board is approving eminent domain or not because the petition is for eminent domain.
And I understand that has been a large portion of the discussion, but to be clear, eminent domain is actually just one piece of this. What this hearing really is for what's called a permit under Iowa Code 479B. Do you understand that?
So they're asking for permission to use eminent domain.
Where
Is that-
the application is actually for a permit to construct and operate a pipeline, and eminent domain can come along with that permit. Is that your understanding? Are you aware of that?
I don't think I can answer that question because I don't feel like I really understand what you're saying. So I really would rather not give an answer.
Are you aware that once the board grants a legal definition for a permanent easement, that Summit would not be able to move the line outside of that permanent easement without coming back to the Utilities Board? Are you aware of that?
Would you repeat that again, please?
Sure. Are you aware that once the board grants a permit for a described permanent easement, that Summit cannot move its route outside of that permanent easement without coming back to the Utilities Board for approval?
And I don't think I'm going to answer that because I'm not at all, this is the first time I've heard this.
I have a feeling that might be the case. Can we pull up page 5 of Ms. Frieder's Exhibit H? Can we zoom in a little bit to the relevant part down there in Ms. Frieders, do you understand that if the board grants eminent domain, that the only portion of the property that Summit will be allowed to construct on is what's shown down there in that lower left-hand corner?
That's not my understanding of the easement agreement that we will have to sign.
And I understand that the voluntary easement agreement may be a little different. I'm asking that if eminent domain is granted, do you understand that this is the only portion of your property on which Summit will be permitted to construct the pipeline?
The only easement I've seen is what we would need to sign. So I really don't know what, I don't know what the other things you're speaking of are about.
No further questions, Your Honor.
Okay, thank you. Ms. Ryan?
Thank you, Your Honor. Good morning, Ms. Frieder. I'd like to follow up on some of those questions you were asking. Mr. Dublinsky asked you a lot of questions about do you understand, and then made a statement. And it sounded like you don't know any of that. You were unfamiliar with that. Is that correct?
I would say that's probably true. Some of it is because I'm trying to just simply follow the whole question in my mind. And sometimes if I can see something on paper and look at it and reread it, I do better with it. But in general, I would say what they were talking about, no, I would need to read something about it.
Did anyone from Summit ever explain any of those items to you?
We did not have any lengthy conversations with Summit.
Do you recall if you've ever received anything in the mail explaining those items?
I don't recall that. But I don't know. At this moment, no, I don't remember anything like that.
Would it have been helpful to have that kind of information before coming to testify to the board?
Well, yes.
Do you feel, scratch that, let me start over. There was one time when Mr. Dublinsky asked you a question, and you responded by asking him a question. Would it have been helpful for Summit's witnesses to testify first, so you would have some answers?
If they could explain everything that they want to do, of course it would be helpful in great detail.
Thank you. That's all my questions.
Board Member Burns, any questions? Okay. Thank you. Thank you, Ms. Frieders. We appreciate it. You're excused.
Thank you. Thank you for listening.
We will take a quick, go off the record and take a quick 15-minute break. We will be back here at shortly before 11 o'clock, so 10:58 we'll call